necessarily at this time I would be eligible for reparations under CARICOM. Well, let's say I moved to Jamaica or Trinidad tomorrow, or I was there for 2, 3 generations. It's still not clear if I would be eligible for reparations there in that country, even if I was, third, fourth generation, Black person who immigrated there. And even if I was eligible for reparations under CARICOM in those two scenarios, it will probably be because, given the independence movements of these Caribbean countries in the 50s, 60s, and 70s, more or less, we're taking into account outside forces, but more or less, they own their countries, they run their courts. And so, Black majority countries. And so it wouldn't be too far of a stretch, if I were to be eligible in that particular context. But we know that that's not the context that we live in today in the state of California or in the United States more largely. But then also someone who studied international law and human rights. I wanted to say that basing the standard on the descendants of slaves or a lineage-based standard, I think could ring positively on an international level, because there are descendants of enslaved people or descendants of slaves in a variety of different societies in this around the world, right? You have the Dalits or the untouchables in India who are relegated to the bottom caste of their society, who, despite this discrimination being thousands of years old and there's been some reform, these people, the Dalits, the untouchables, still have to live on the bottom caste of their society by virtue of them being descendant of, people relegated to the bottom caste. You have the Ohu and the Osu tribes in Nigeria, present-day Nigeria. These are the descendants of slaves themselves. And some of us, actually Black Americans, if you do your genealogy and DNA, you actually might find that you were related to Ohu or Osu, which are, tribes that are relegated to be slaves. And to this day, the Ohu and the Osu deal with certain social stigmas and political stigmas. They can't marry unnecessarily an Igbo or Yoruba because they're Ohu and Osu. You have descendants of slaves in the Sahel region, like Mauritania and Madagascar. It would send a very powerful message, I believe, in my personal opinion, as someone who studied international law, that the United States, the most powerful country in the world, or in the context of the state of California, the fifth largest economy in the world, is making a declarative statement that we care about the descendants of enslaved people and we're committed to repairing them. And so that would send a powerful message to the rest of the world that, descendants of enslaved people, the stigma around that identity needs to be eradicated indefinitely. And then I also had a question for Member Tamaki, and I was curious to know, were there, non-Japanese people who faced internment that were not deemed eligible for reparations through the redress campaign?
The answer is yes. The issues that the Black community is facing, it brings back memories about our own issues and conflicts. And at the end of the day, there were whole entire groups that were eliminated from the reparations, process. I mean, certainly right out of the gate, if people were dead by the time that the reparations bill actually passed, they were not eligible. The folks that actually got a reparations was less than half of the population incarcerated. Why? Because they had passed away. The other piece of it was there were about 4,000 Japanese living in Peru who had immigrated from Japan and Peru at the early turn of the century. And the United States, because it had this preposterous idea that Japan would trade American prisoners of war in a prisoner exchange with Japanese, even if they were from Peru, the American government literally kidnapped about 5,000 Peruvian Japanese and put them in American concentration camps in Texas and other areas. And at the end of the day, the organizers of the bill felt that Congress would not pass a bill which provided reparations to Peruvian Japanese. And because right after when the war ended, because political leaders said that they had entered the country illegally, that they did not have proper papers. Some of them were deported, but not to Peru, to war-torn Japan that they had never been to, because they were born in Peru. So there were very difficult and hard decisions that were made. I'm not defending those, but that's factually the reality. I did want to say a couple words, knowing that the time is short, about my position on this. And I wanted to defer to the other Black members of the task force. And I noticed that Lisa hasn't spoken yet, and I certainly want to defer to her. But as the only non-Black person on the task force, I've been approaching this with humility and a sense of humbleness. And from our own experience, I realize that this is something that is just deeply, intensely personal. I mean, people here feel the burden of generations. I think people talked about speaking for family members. I did not know that Reggie Jones Sawyer's uncle was part of the Little Rock Nine, for instance, and other people have told, their stories. So this is not an abstract policy issue. This goes directly to the identity of who folks are and their family members and their ancestors. So I deeply appreciate that. I would say, as far as a class of harmed people specifically, for this period in American history, I think, as other people said, I think this is the starting point. I think that group that has not been acknowledged and has repeatedly been ignored of descendants of slavery have to be acknowledged as a starting point. What I'm having trouble with and the most difficulty with, I think Assemblyman Jones Sawyer articulated this wonderfully and eloquently, and that is the continuing harm that happened post-emancipation. That is really based upon anti-Black hatred, anti-Black prejudice. And it goes to the core of guarantees of non-repetition. And we heard hours and hours of testimony how slavery and that institution of enslavement morphed into the next generation, the next iteration of oppression, whether it was Jim Crow or separate but equal or racial terror or exclusion or redlining. So, for example, whereas the redlining and the restrictive covenants were very clear and very express about excluding people, it morphed into other things now, algorithms, zip codes, criminal justice system. We've heard testimony on education, employment. And so the guarantee of non-repetition has to be reflected in policy changes. And in some cases, direct repair. I mean, for those who've lost their homes because they were confiscated, Bruce's Beach, Allensworth, San Francisco, Fillmore, the Bayview Hunters Point, Richmond, environmental racism, that people face pollution and terrible health problems. I mean, those are harms, and it's difficult to parse out and divide that harm in the sense of descendancy as opposed to just the reality of anti-Black racism. So the way I would look at this is absolutely the descendants of American slavery have to be recognized. That has to be addressed, no question. But the continuing harms of today, I thought Assemblyman Jones Sawyer said this so eloquently. I think that is also within the charge of this task force. So as we proceed on this and begin to unpack things like the difficulty of lineage and how to trace that, that might be the only tool available, might be what we have. But I would really like to know from the experts, how difficult is this going to be for a foster child, for instance, to be able to trace their lineage back? Nevertheless, that said, no matter how difficult that is, I think that class of harmed people has to be recognized. So I'll just stop there. And again, I really want to defer to all the members, and particularly Lisa, who has not spoken yet.
Madam Chair, if I might, with a point of information, you are at 11:15. The task force can do a number of things. You can extend the time for this, change around your agenda that will allow you to move into that spot. You can ask for a motion to approve or otherwise define the community, or you can table the action, or you can vote. I heard one member indicate asking if there could be a limited or a temporary vote, and there is a mechanism where you can move as a community of the whole and then take an action that will not be final. So those are your kind of some of the options you have, but you are into another agenda item as far as time. Thank you.
Thank you. So we'll extend the conversation for another 15 minutes. So we'll take member Holder's comment, and yeah, we can call for a motion. Member Holder, you're recognized.
I appreciate the time and space to discuss this pivotal issue, and for the acknowledgement among my esteemed colleagues here that this is not a simple issue, that this is not a black and white issue, and that this is a highly, deeply personal issue for all of us who have Black skin, especially. Reparations is about harm. And reparations is about repairing harm. And as a body that is deciding on reparations for the first time at such a high level, the way that we proceed is going to have a huge impact on the way other states proceed and on the way the federal government eventually proceeds. Our process will be emblematic. Our decisions around issues like eligibility will be emblematic, and they will be resounding, and they will resonate over time. So this is not an easy matter. Harm. The harm that we have discussed and that we have talked about over the last 8 months is a harm that started 400 years ago, and it is a harm that has morphed and continued into the present day. And the evidence and testimony that we've heard from experts indicates that it is a harm that will continue into the future. And so one of our tasks is to find mechanisms to make amends for those harms of the past, find mechanisms to abate the harms in the present, to stop it now, and find mechanisms to ensure that the harms don't continue into the future. The present and future harms that we're talking about are harms about anti-Blackness. They are grounded in a convention of white supremacy and in a convention of anti-Blackness that began the time of slavery, but it's continuing today. And if you have Black skin, you are catching hell in this country. I will tell you a very personal story that talks about the harms that you face as a Black woman in this country today. 14 years ago to this date, when I gave birth to my child, who I carried for 9 months, and during that harrowing process, that experience, I explained to my doctors that there was something wrong. There was something wrong. There was something not right. This child had been in my body for 9 months, and I knew something was not right. And I was virtually ignored. I believe I was ignored because I was a young Black woman, because my skin was Black. No one asked me if my ancestors were enslaved in the United States, or if they were enslaved in Jamaica, or if they were enslaved in Barbados. All they saw was my Black skin. My baby died at the time of delivery. That should have been a healthy child. That child should be alive today and should be a part of my life, and I should have had that experience of motherhood. I did not have that experience because of my Black skin. We've heard so much about the crisis in healthcare and how it impacts Black people specifically because of anti-Black racism. And we have to protect one another. 90% of us were enslaved. 90% of the Black people in this country descend from slavery. And in this moment, we have to embrace this concept that Black lives matter, not just a sliver of those Black lives, because Black lives are in danger, especially today. And so I believe that it is our task to not be too specific, but to recognize that this is a collective harm that requires a collective remedy. And this is not just a problem that all Black people face in policing. It's a problem that anyone with Black skin faces at every moment, every point in time, every moment of their being in this country. When you go into the hospital, when you apply for a loan to try and get a mortgage, when you try to get an appraisal, people are focused on your Black skin, not necessarily your lineage. That is the harm that we are facing today. So with that, I will say that I recognize the importance of the language of the bill and the special consideration language. I value that. I value Dr. Weber's vision, and I do think that we should have a tiered policy, and we should have a tiered eligibility criteria that starts with descendants of slaves born in the United States. But we also have to embrace what is happening to our Black family now. We have to retain our solidarity. And that is both a practical consideration and it is also a philosophical consideration. Practically speaking, going forward, we will need our entire family, our entire Black family, to move this legislation forward. We are going to need, we can't erase a part of that family, because that is where the political will lies. That is where the solidarity lies. And we have to move forward together. We can't start disaggregating to the point where we split up apart. We split apart into a million pieces that has no real power or real momentum. Finally, I will say, I appreciate and value Professor Chemerinsky and what the knowledge and the brilliance he has brought to the legal community. I have been an attorney for 20 years, and I have been on the battlefield, on the front lines, in the courtroom, raising issues of equal protection and weaponizing that law to try and protect Black people. I'm a litigator. Okay, so I actually understand that mechanism and how the law can be used. And there's variations in views about race neutrality and whether that is the only way to go forward legally in this moment. Not everyone agrees with that. That's a highly pessimistic view. One of the things that I mentioned to Professor Chemerinsky is that when you're talking about continuing harms are recognized by the federal courts, even if they are grounded in race, right? That's why you have things like diversity studies. That's why you have things like adversity studies, right? And you know, you can, if you can show that the government is continuing to project harms onto people of a certain race, then you do have a mechanism under equal protection to move forward. And it's just so hard to take race out of this process when it is so much about race. And so to the extent that there is a mechanism and we can think creatively, legally about how to move forward while recognizing that race is the foundation for this claim, we have to really struggle with that, grapple with that, and try and figure out how to move forward. And as far as Proposition 209, I've been waging a war against Proposition 209 for 20 years. I understand Proposition 209. I understand where the fault lines are and how we can maneuver around it. And it's very simple. We're going to have to focus our legislation on things other than government contracting, government employment, and government education. Focus on housing, focus on land reparations, focus on mechanisms for improving health care, focus on the tax structure, and giving people tax credits and tax abatements. That does not implicate Proposition 209. So I take a much more optimistic view about how to navigate equal protection and Proposition 209. And we should not approach this with fear in our hearts. We should approach this with hope.
Thank you. Thank you, Member Holder. So being mindful of time, so we'll have 5 more minutes. I would like to take the time and space to acknowledge any members who would like to make a motion.
Madam Chair, okay. I just wanted to say, excuse me, Member Jones Sawyer had his hand up a little bit ago.
Okay, yes, before I recognize Reggie Jones Sawyer, I would like to say that I think it's important that we don't redefine kind of what the legislative intent was based on what Weber said, and I think based on the bill language, and I think Member Montgomery Steppe followed up with that after Member Jones Sawyer spoke, when she said that the bill it's following a particular history and lineage. For instance, it says, as a result of the historic and continued discrimination, African Americans continue to suffer debilitating economic, educational, and health hardships, including but not limited to the following. And then that's when it gets into things like incarceration and unemployment. So that section in the legislative findings, it's pretty clear that it's not necessarily a race-based standard, but a lineage-based standard by virtue of the historic and continued discrimination that these particular groups continue to suffer. Yes. And also I wanted to say one last thing. I had a conversation a few days ago with Black Brazilians and Black Colombians, and it was a conversation about, Black people who lived in, historically slave societies. And a Black Brazilian friend, she said, I know it sounds bad, but I would rather live in America versus Brazil because, the history of discrimination in Brazil, as a Black Brazilian, I feel more comfortable living in America. And then I told her, well, that's interesting because I feel more comfortable in Brazil than in America. Because I told her I have faced a lot of discrimination as a Black American woman in the United States. But in Brazil, because I don't have that same relationship, because I'm not a descendant of an enslaved person in that particular society, there's certain stigmas that are not attached to me. And I think that we also have to be kind of aware of that relationship as well. Member Reggie Jones Sawyer, you are recognized.
So in the interest of time, it appears that the majority of the members of this board have more questions that need to be answered. I would like to make a motion that we table this to the next meeting with some kind of instructions on what additional. I want to continue the conversation, and I think this is real robust. And I think giving it just 1 hour doesn't give it justice, and that we go ahead and set aside more discussion, but also get more information, whether it's lineage or just answer each of the members' questions that had additional questions and get those answered by DOJ or whomever so that we can make an informed decision on this. And so I would like to make a motion that we table this to the next meeting and that we don't let it drop, and that hopefully we can even maybe come up with some guidelines on how we can come to an ultimate decision on how we're going to do this, what we need. I heard that some of us even want to hear some more input from other individuals. But at the end of the day, my gut is we need a little more time than just to vote right now.
Yes.
Okay, so there's a motion on the floor to table the discussion till next month. Is there a second? Hearing no second, the motion.
Well, I will. I think there is a degree of unreadiness here, and I think it's been a lot of great discussion here today. But I too think I don't want to feel like we're rushed into something because it's been brilliant arguments on all sides, and I just think we can flesh this out a little bit more. And so I don't see the need to necessarily take this action up today. So I will second that motion as well.
That the discussion or vote on the community of eligibility is postponed to next meeting in March. Is there any discussion on the matter?
There's no discussion, Madam Chair. You just go straight to the vote.
Straight to the vote, parliamentary procedure.
Parliamentarian Johnson, you may cue the roll call vote.
Okay. Chair Moore?
No.
Vice Chair Brown? Member Bradford?
Aye.
Hello? Excuse me.
Member
Brown's a no.
Grills? Brown's a no. Okay. Thank you.
What is it? What is the message? Was the message? I'm sorry.
I'm sorry. Vice Chair Brown, we're voting on to table the motion until the next meeting.
My vote is no.
Member Grills?
Aye.
Member Holder?
Aye.
Member Jones Sawyer?
Aye.
Member Lewis?
No.
Member Tamaki?
Aye.
Member Montgomery Steppe?
No.
Madam Chair, 9 members voted. There were 5 ayes and 4 noes.
Thank you. So there are 5 ayes and 4 noes. So the ayes have it and the motion carries. The discussion and vote on the community of eligibility will be postponed to March. Thank you. Okay, so we'll now turn to the next item on our agenda, which is number 15, potential action item, expert consultants for second report. And we are running low on time, so we have 30 minutes roughly for this part of the agenda, and then we'll go to lunch, which will run from noon to 1. So are the expert consultants all here? I believe so. I guess we'll start this part of the agenda by having the DOJ Research Center facilitate introductions for the experts.
Good morning, esteemed members of the AB 3121 Task Force. I'm Dr. Tiffany Janstazamo, and I work at the DOJ Research Center. I'm honored to present to you the group of scholars and leaders in their fields who have expressed interest and availability in working with the task force to tackle your second report to the legislature. As you may recall, in the January public hearing, the task force requested this opportunity to meet with the expert researchers who have expressed interest in contributing to this report. Each of the experts are prepared to provide a brief introduction, speak to their credentials, experience, and research expertise. Following these introductions, the task force members are invited to ask any questions of the research experts. And the experts have also expressed in previous meetings that they may have questions for the task force members as well that may guide their efforts in drafting a scope of work to be presented at a future public hearing. So without further ado, I will turn it over to Dr. William Spriggs to kick off the introductions.
Thank you for the opportunity. My name is William Spriggs. I appeared before you before as a witness. I'm a professor of economics at Howard University. I hold a PhD in economics from the University of Wisconsin-Madison. My dissertation at the University of Wisconsin was on African American wealth accumulation in Virginia during the post-slavery era. And in it, I posed the question of what generated the Black-white wealth gap, and then gave estimates based on differences because of discrimination in employment and the ability to buy land, and looked at all of the avenues by which I could demonstrate that there were impediments. As the research director for the National Urban League's Institute for Opportunity and Equality, one of my previous positions, I took part with the Leadership Conference for Civil Rights of the United States and the UN Conference Against Racism, Xenophobia, and Related Forms of Intolerance in 2001 in South Africa, where in Durban we had a deep discussion about issues of reparations. The bulk of my work is on institutional barriers that Black workers face, but I also do work on difficulties of Black institutions and surviving. That's an important element of the racial wealth gap that often isn't looked at, and it's a little harder to quantify.
Thank you, Dr. Spriggs. We'll move next to Dr. Kesia Campbell.
Hello, everyone. Thank you for having me here. My name is Kesia Campbell. To give you a little history of my background, I am an economist. I have a PhD in economics from Claremont Graduate University. A lot of my research today focuses on macroeconomics and instabilities that exist because of varying institutions that can cause, whether it be recessions or any downplaying economic activity. I also have research that stems into the international field associated with crime, issues dealing with emissions and pollution, issues dealing with environmental degradation, and a host of different micro and macroeconomics type of research for publication. I think one of the particular areas that I wanted to highlight that is very pointed to this particular task force and useful in terms of the training and skills that you would find advantageous is my work in what's called forensic economics, where I calculate specifically damages associated with a varying degree of acts, whether it be wrongful termination, lost profits associated with particular acts, or discrimination, and a host of different pecuniary damages that can exist that usually an economist would calculate. When we think of the institution of slavery and trying to figure out reparation, the damage calculation comes in handy, especially from an economist. That's pretty much what I want to highlight. Again, thank you for having me.
Thank you, Dr. Campbell. We'll move next to Dr. Thomas Kramer.
Thank you very much to the task force for considering me. I've also been an expert witness. My name is Thomas Kramer, and I'm an associate professor of public policy at the University of Connecticut. My research focuses on implicit racial attitudes and race-related policies, especially slavery reparations. I obtained a political science doctorate from the University of Tübingen in my native Germany in 2001, and a political science PhD from Stony Brook University in New York in 2005. I began my research on reparations with public opinion research in 2006 and 2007, basically conducting an experimentally manipulated question wording study where three findings emerged. First, slavery reparations were overwhelmingly unpopular, unsurprisingly. Second, opposition or support crucially depended on question wording. And third, and this was most important to me, white non-Hispanic respondents who identified with African Americans as a group on the non-conscious level, measured through reaction time procedures, were significantly more likely than other white respondents to support slavery reparations, regardless of question wording. In other words, there seemed to be a non-conscious psychological mechanism for interracial political solidarity, and this finding makes me very optimistic. But later I became interested in the question of what order of magnitude slavery reparations might take, and so I published a paper in 2015 titled Estimating Slavery Reparations. It provided a conservative estimate of about $14.2 trillion in 2009 dollars, roughly 1 year's worth of the US GDP at the time. Since then, the estimate has grown to $20.9 trillion in 2022 dollars, grows every year due to compound interest. The estimate is based on historical unskilled hourly wages and an estimate of the total annual man, woman, and child hours that were available to slave owners between 1776 and 1860. The estimate is conservative because it ignores colonial slavery and the Civil War years, and because the historical hourly wages are puny, just a few cents per hour, and because it uses an interest rate of only 3% that's barely sufficient to make up for inflation. In two papers published in 2018, I explored the question of slavery reparations beyond the United States, namely from the predominantly European successors of slave trading powers to the African successors of regions depopulated through the transatlantic slave trade. I've presented my research at reparations conferences in the Gambia, at Tulane Law School, and in South Africa. In a co-authored paper published in 2020 with Professor Darity and other scholars, we investigated ways in which slavery, as well as historical injustices related to slavery, for example, post-slavery racial discrimination in employment and housing, among many other injustices, could be addressed. So that's my background in reparations research. Thank you very much.
Thank you, Dr. Kramer. We'll move next to Dr. William Sandy Darity. I believe he is calling in. I apologize for the delay. We were having a little.
Can you all hear us?
Oh, yes, fantastic. Thank you.
Yeah.
All right, we'll move to Dr. Darity and author and folklorist Kirsten Mullen.
Okay. So I'd like to begin, and I'd like to ask if the task force would indulge me in a moment making a slightly longer statement than my colleagues. Chair Moore, Vice Chair Brown, members of the California Reparations Task Force, I'm very privileged to be considered as a potential member of your expert consultant team that will provide advice to the task force on its second report. My name is William Darity, Jr. I'm the Samuel Du Bois Cooks Professor of Public Policy, African and African American Studies, Economics, and Business at Duke University. I also serve as the director of the Samuel Du Bois Cooks Center for Social Equity. I received a PhD in economics from the Massachusetts Institute of Technology in 1978. Kirsten Mullen and I are serving currently as pro bono consultants to the California Department of Justice team that is supporting the task force. One of our major tasks has been to provide critical reviews of the chapters that are being prepared for the first task force report. I have engaged in more than 3 decades of sustained research on the design of a scheme for reparations for African Americans. And among the signal events that are associated with that research was the introduction that I prepared for Richard America's edited volume, The Wealth of Races, in 1990, which was an attempt to provide a collection of essays that involved economists estimating the cost of a reparations plan. And as Thomas Kramer mentioned, in 2020, we co-authored a paper that extended these types of estimates. In addition, I co-authored a paper with Dania Frank Francis that was published in the American Economic Association's Papers and Proceedings in May 2003, where we began this process of trying to outline how a detailed plan for reparations would look. I've written a number of opinion pieces with Kirsten Mullen, including one called The Big Payback that was published by The Root in July 2008. I provided written testimony that was submitted to the House Judiciary Committee on their June 19th, 2009 hearing on H.R. 40. And then, I guess most significant, Kirsten Mullen and I published From Here to Equality, Reparations for Black Americans in the 21st Century in the year 2020. The book includes the description of a systematic plan for reparations that addresses standards for eligibility, the size of the bill, who should pay, we conclude it's the federal government, and the form of distribution that should be conducted with the use of the funds. I want to say that for what is decisive for us in terms of trying to gauge the size of a reparations bill is the magnitude of the racial wealth gap in the United States, which from our perspective captures the cumulative intergenerational effects of white supremacy. The estimates from the Survey of Consumer Finances from the Federal Reserve indicate that type of disparity amounts to $840,000 per household on average, which would constitute approximately $350,000 per individual. For a family of 4, it would constitute $1.4 million. Would this solve all problems? Would this eliminate racism? No, not necessarily. But the reallocation of resources on that size to Black families in the United States is an experiment that we think is well worth running. The total would amount to $14 trillion to be distributed over 40 million eligible recipients. The states and localities cannot meet this bill. And this is, of course, an artifact of the contradictions and tensions that you've been struggling with associated with trying to address what is fundamentally a national problem at the state level. The total budgets of all states and localities in the United States are less than $3.5 trillion. And that's considerably less than the $14 trillion minimum that would be required to eliminate the racial wealth gap. And California alone can't do it either. Suppose we allocated $350,000 to each of the 2.3 million Black residents of the state of California. That would come to approximately $805 billion. If we limited that allocation to the approximately 2 million Black Californians who are descendants of persons enslaved in the United States, that would come to $700 billion. The total budget for the state of California is only $260 billion. And the budget surplus is $31 billion. Suppose only the surplus was used. The average payout from the surplus would be in the vicinity of $15,000 to $16,000, which is less than the symbolic $25,000 housing voucher projected payouts in Evanston. So what might California do substantively, since it cannot meet the requirements for a comprehensive plan for reparations? I would suggest that the task force may want to consider 2 steps. First, identify racially motivated atrocities that are specific to California. And second, support individuals in bringing claims forward having been subjected to such harms. The task or scope of work for the consultant team under such an arrangement would be for us to identify ways in which monetary compensation can be assigned to each individual claimant who has been subjected to these atrocities. And Kirsten Mullen, in her remarks, will talk about the process of identification of the atrocities.
I'm Kirsten Mullen, author, folklorist, and arts consultant. My related academic work has focused on anthropology and folklore. I have directed arts programming and conducted research on a range of cultural topics: Black material culture across 4 centuries, Black vernacular musicians, architects, artisans, and crafts workers, financing Black cultural institutions, and I have supported museum exhibitions. I was a member of the Freelon Ajay Bond Smith Group's concept development team that established the rationale for the National Museum of African American History and Culture in Washington, D.C. My work helped to justify the location of the Black Smithsonian on the National Mall, and I edited the team's 4-volume submission, which included the work of over 20 individuals, architects, engineers, archivists, historians, curators, and educators among them. I also coordinated and turned around 12 rounds of responses to Smithsonian staff members, responding to their questions under tight deadlines. Over the past 30 years, my work has been published in museum catalogs, academic journals, and commercial magazines. And I have contributed to a number of white papers and editorial opinion editorials. And as Andy said, I am the co-author with him of the award-winning From Here to Equality. So, what does this assignment require of the task force? The task force must direct its measurement team to itemize a set of atrocities and calculate the financial value of those losses, or it must direct the team to identify a victimized population and assign an amount of compensation to each of its members. What is the work and what are the challenges? In both instances, the measurement team would be guided by the task force decision about which type of approach to compensation will be undertaken. Then, to the best of their ability, the measurement team will provide estimates of what that compensation would be. In instances where there is insufficient information to make those calculations, the measurement team will provide formulae for calculating the compensation and indicate what data is needed to produce those estimates. Any determination will be preliminary. Hence, you may not wish to establish a statute of limitations, that is, the time limit for making claims against the state of California. So, on the process to deliver some form of restitution, there are 3 steps, basically: to design the methodology, calculate the damages, and distribute financial awards or monetary payments to eligible recipients. Harms specific to California. Federal programs like the New Deal, the Servicemen's Readjustment Act of 1944, also known as the GI Bill, and the federal highway system were designed to give states and localities discretion over their application. California was no exception. Next, I would to talk briefly about 5 potential categories of harm to consider. So Congress approved the Federal Highway Act in 1953, authorizing massive public works projects. A network of roads stretching across 41,000 miles, connecting 42 state capitals and nearly every city with a population above 50,000. Then President Dwight Eisenhower called the initiative, quote, essential to the national interest, end quote. Disproportionate property takings through eminent domain, including the state and international highway system and other road extensions, stadiums, water utility facilities, and the construction of power lines, have displaced 475,000 households and more than 1 million people nationwide, a disproportionate number of them Black residents. This single piece of legislation enabled the condemnation of, quote, unwelcomed, blighted Black neighborhoods, end quote. The influence of New York's urban planning czar, Robert Moses, extended far beyond his state's borders. Moses was also the chair of New York's Slum Clearance Committee, and he believed that, quote, the best way to eradicate the supposed slums where Black people lived is to build highways through them. We know a lot about the highway system in the state. Research would reveal that the value of the comparable homes in Black versus white neighborhoods during 1950s was skewed. We would need to know the amount of down payments and the interest paid on those houses, the amount of money Black and white families were given by the city for comparable properties. As an adjunct to whatever direction the task force decides to take, it will need to put forward a plan that includes the allocation of resources for a substantial research unit to assist the claimants in pulling together the evidence that they will require so they can establish their claims. I'm not going to list the major highways, but there are at least 10 major highways that you might want to target initially. The health conditions of families that live near these highways but did not receive financial assistance to relocate, depression, continuous air and noise pollution, asthma, coronary artery disease, reduced ability of one's lungs to function, impaired lung development in children, preterm and low birth weight infants, child leukemia, premature deaths, and the toll in heart attacks and suicides. Possible sources of data needed to calculate the loss in financial terms include the U.S. Census data. The 1950 census will be released in April 2022 and will be an invaluable resource for identifying individuals in the affected neighborhoods, but also the archives of city planning departments and urban renewal initiatives. Second, over-incarceration of Black women and men and police violence against unarmed Blacks. The enforcement of supposedly race-neutral laws disfavored Black people. Blacks are treated more harshly by the police during pretrial. They're charged with more serious crimes and sentenced more harshly than whites. The measurement team would calculate the cost of the financial, mental, and physical health repercussions for these incarcerated and their families. Houselessness. One of your witnesses, Carolyn Roberts, who testified before the task force on the 27th of January, revealed that 27% of the state's houseless residents are Black people. Among the health effects this community shares are a wider incidence of schizophrenia. Fourth, under public health education, the elimination of racialized tracking in schools and decreasing rates of suspensions and expulsions of Black children. It would be important to calculate the effects of the mental and health conditions of these Black kids subjected to low expectations, punitive treatments, their over concentration in under challenging classes and under concentration in challenging classes expose them to gifted behaviors. Proposition 209 basically destroyed affirmative action. And one of the results is the dramatic reduction of Black students attending the state's colleges and universities. And then fifthly, official commissions. Should membership on all municipal and state commissions and committees be representative of the state's demographics or that of local populations, knowing that those populations are a consequence of historic events? Some general questions. Will you establish a residency requirement, and what criteria will you apply? Is it the possession of a driver's license, continuous physical presence in California for 365 days, or 3 years, or 7, with evidence the individual wishes to make California their permanent residence, that is, has severed their legal ties to previous residences, or have paid state taxes? Will it be ancestors linked? Ancestors who established continuous physical presence in California since the 9th of September, 1850, statehood, or 1865, when post-emancipation of emancipated Black people in the United States occurred, or 1965, post-passage of the Civil Rights Act legislation, or 1922, 100 years ago. You need to set a starting point. Will you consider former California residents who no longer live in the state? If you go the route of awarding individuals who could make claims for the atrocities they suffered at the hands of the state when they were residents, that would open the door to paying restitution to individuals who no longer live in California. Will you consider the case of Native Americans who were enslaved in California from 1850 to 1863, when the Emancipation Proclamation was declared, and who were subjected to the institutions through 1870 when it effectively died out? We would recommend that you err on the side of leniency, design application process in such a manner that individuals are encouraged to apply, but research initiatives should be undertaken by a state agency, perhaps a racial equity office, and that the services of their staff should be provided free of charge.
Thank you, Dr. Darity and Kirsten Mullen, for your introductions. Thank you to all of the research experts for your time and your introductions. I'm going to yield the floor to the task force to ask the experts questions.
Thank you very much. So are there any questions or comments for the experts? Member Grills, you're recognized.
I'll let Member Scott Lewis go first. No, you have the expertise. You said that last time, so let's hear what you have to say.
Fair enough. Well, I have a lot to say, I guess, but I'll limit myself. So the big concern that I have is, so we've just voted to delay our decision around the community of eligibility, and so I want to know, how will that impact the work that we will be asking you to do, in terms of determining, the scope of work.
I'll start by answering your discussions were too abstract. So it really does depend on what is the question and what is the approach you're taking. The approach that Dr. Darity laid out for, and that I had in my dissertation for understanding the cumulative effects of discrimination, assumed assigning to each African American some sort of average amount of the payment, averaging it across everybody. So it meant that we had an agreed upon starting point in whatever model we're using, and then you have some end date. And what's the disparity at that end date? And so you still haven't established what's the beginning. Is it inequality in California when it entered as a state? Is it 1860 or 1865? When you listen to many of the people who testified, they want restitution for slavery that did not take place in California. They want restitution for discrimination that did not take place in California. And so they're asking for restitution for American discrimination, American slavery. And so you would still have to give us a starting point for, if you're going to make restitution for that, for whom, when? Is it for people who were in California in 1940 forward? If you're not going to limit it that way, then, so we need, you have to be more clear about precisely what you're asking for in terms of thinking about, is it broadly speaking, American institutionalized racism? Second, if it's things specific to California, and Dr. Darity and Dr. Mullen went over this. When I gave you a presentation on discrimination against Black teachers, there are two groups potentially that could be upset because California didn't hire Blacks in public school education. when I testified, I pointed out to you that if you look in the 1940 census and look for people who had been born in California, had a college degree, and where were they teaching, none of them were teaching in California. One of them is one of the most famous professors at Howard University, Ralph Bunche. So, but he left. Are you saying that this type of discrimination can't be compensated because those people were discriminated against in California and left California, so you're not going to compensate them because only somebody who lives in California today gets compensated for something that California did? That California did, not Mississippi, not Louisiana, not Arkansas, something California did. We know there's been out-migration of Black people from California because of discrimination in California. There are Black people who left California in different sorts of ways. Are you going to include them, even though they've left? I mean, these are the types of questions which you didn't narrow down for us. If you take the position that I agree with, and I would endorse that Dr. Darity and Ms. Mullen laid out, that it's specific actions, and you want to always be free, you want to make a recommendation, let's say, that there will be ongoing investigations of acts that California engaged in, and we want a process by which people may be redressed, because these were acts we say were with racial animus. And so going forward, you want a calculation. Then you're going to have to confront this issue of that you were discussing. If someone came from the Caribbean to the United States in the 1900 wave, came to California, and they are amongst those Black people who lived in the neighborhood where a highway was designed to destroy the Black neighborhood, are you saying you're going to not compensate them? They have no claim. The other problem we have is the general model that we do, which is to say, okay, what is the Black-white wealth gap? Dr. Darity is the only person I know of who has conducted large enough samples to break down the Black category between people you might think were the descendants of slaves or not. The vast majority of data that we have is for Black people in America. We have no knowledge of their lineage. So if you asked us to model what's the general effect of discrimination and how does and what would be our estimate of the average impact for Black people, that's not the descendants of slaves, that's Black people, because we only have the wealth of Black people. We do not have the wealth of the descendant of slaves. So part of it would be a challenge for us, that we couldn't be as specific in our answer. We could tell you, well, the majority of them are Black, descendant of slaves. We could tell you it was 90%, or we could try and estimate based on what we know of from the data. But that would be an issue. So for us to be able to tell you your eligibility thing, it really is going to require some refinement as to what you think you're compensating for and the process you want to have going forward. But these are the things that you need to include in your discussion, because there are clearly people who have suffered discrimination because of institutional things California did who no longer live in California. There are clearly people who have suffered from discrimination who did not live in California. And when is it that they must have appeared? If somebody moved to California in 2005, are you saying that you'll compensate them for something that happened in the United States? Is there a cutoff by which I must have arrived in California?
Dr. Campbell.
Thank you for asking that question, Member Lewis. Because I came on early specifically for that agenda item in terms of the community of eligibility, because it frames our methodology. If I'm being honest, without it, I honestly don't know where to start. Gives us a model and a framework to figure out exactly who this population is. Because on one end, the idea is if it is direct descendants of slavery, then there is a very specific damage that happened. It's that institution of slavery. And what it extracted from these enslaved individuals can be very specific. You know, as human beings, what we call the economic animal, we are endowed with particular resources or labor or land or capital and our enterprising spirit. And when the institution of slavery, if that's the population that's defined, removes that, then the losses are very specific. It's the lost wages, like what Professor Kramer has calculated in the past. And when we no longer have land, then it's the lost rents associated with that. When we no longer have our enterprising spirit, then it's the lost profits that's associated with that. When we no longer have capital, then it's the lost interest that's associated with that. So when that population is defined, it allows for a framework and a methodology to figure things out. If it is the case where we don't have that particular population defined for us, a community of eligibility, Dr. Grills mentioned something earlier, and it's probably something the task force has to kind of hash out, where what about this kind of twofold approach where the options are presented to the task force? So very specifically, this community of eligibility being direct descendants of slavery, and along the lines of what Dr. Darity and Kristen Moran were talking about earlier, was these harms that can be quantified and be very specific, and a process of putting through a claim, which is a little bit more involved, is kind of defined. But all of this is to say that without this community of eligibility being defined for us, my fear is it becomes an academic exercise, and that's not what we're here to do. We're here to be very specific with these are the individuals that are harmed. This is the methodology that's in place. This is the evidence to support it, and then that's presented in a manner that can be very defensible. So your question earlier, how does that affect us in a very big way? Because now we find it hard to move from the abstract.
Thank you. More, you're muted.
Okay. Excuse me for that. So now, I wanted to leave the space to for any of the task force members to entertain a motion as it relates to the presentations that we heard from the economic consultants in terms of the scope of work.
Excuse me, Chair Moore, I actually had a question and I yielded to Member Lewis to go first.
Sorry about that.
That's okay.
Member Gross, you're recognized.
Okay, thank you. I very, very much appreciate the comments that have been made by the this panel. And in fact, it gets to the questions and concerns I had. Like, is it possible, because we don't, we're not economists, political scientists per se. And so we don't know what the variables are that you need to construct your calculation. So at some point, would we be able to get a list of, we need you to set the parameters for A, B, C, D, and E. And then once we get that, we'll have some follow-up questions on X, Y, and Z. Because I think that you added more to the conversation around things that we as a task force have not yet discussed, because we didn't necessarily know what we needed to share with you in order for you to complete your work, other than the community of eligibility component. And so I think that if we could get a roadmap of things that you need to know in order to direct, and community of eligibility is one of them, but you've laid out several more, that then we can have the discussions to provide you back with concrete answers, because absolutely, this is not about an academic exercise in the abstract. It is about identifying specificities and concrete remedies. That being said as well, is that feasible, what Member Holder I suggested, and I suggested in my comments in the earlier discussion, that there doesn't have to be a one size fits all. Can there be a tiered kind of calculation? Special consideration first and foremost to descendants. But then, because the AB 3121 directs us to the legacy of enslavement, what were the ongoing harms up to the present moment? As that wonderful example that you gave, Professor Spriggs, what happens to the people where the freeway cut right through their neighborhood, and they weren't a descendant, but they were of African ancestry, and so they were harmed as much as the rest of us. So is that feasible to think about a tiered approach or a layered approach to coming up with calculations?
Yes, but it gets to this philosophical, what are you seeking the reparations for? If you mean broad injustices in the United States, and then we're going to abstract from the history of California not being part of the English United States and only becoming a part of the political United States in 1850 or so, right? Are you saying we want California, with its own history, to compensate the victims of American slavery? And then for what? Are you saying there's no statute of limitations? We just want compensation for the lost wages, the calculation that Dr. Kramer talked about. If you took the model of wealth accumulation, understand that the majority of white people descend from somebody who came after slavery, and large numbers of them came with nothing. And yet, the average wealth of white people dwarfs that of black people. Clearly, slavery has little to do, as much as we may have that sense, that attachment, emotional attachment to it, to the current wealth gap. Most of the current wealth gap is the result of the 100 and some years after slavery, in which we were repeatedly, different from everybody else, prevented going from zero to anything. And if you say I want a calculation that compensates that zero to something that makes it that when I talk to my neighbor and they say, why do you want compensation? My relative came from Ireland and they only had $8 in their pocket. They came in 1900 and look at me. If you want, no, here's the document. This is why, even though my relatives were here in 1865, I couldn't do what your relatives did. And so I want compensation for that. See, that has a start point and end point. And this is where people would say, well, prove you were here in 1865. And then we can give you a calculation. It will be very imprecise because we don't have the wealth of only the descendants. We have the wealth of Black people to compare to. Or are you going to say this would be very difficult? Because if you're saying I'm abstracting from California, and I'm taking on the federal responsibility, and then you know, where can any Black person come to California and say you're compensating Black people for American institutional racism? I want my check from California. Because if that's what you're saying, California says it's going to compensate everybody who was wronged by U.S. slavery. If you're saying, well, no, only people who lived in California as of 2020, only Black people lived in California as of 1900, at which point? So you'd have to give us that information too. Or you would have to admit that here's the problem. People mitigate against discrimination in the U.S. The reason we have felt free as economists to talk about it as a group and talk about these calculations as a group is because we're averaging it out. And we're saying, yes, many people fled Louisiana, Texas, Oklahoma, Mississippi to California because they didn't face the same discrimination. And when we make our calculation and average it out, it's not saying that every Black person faced the same amount. We're blaming America for this average disparity. But if you ask me for a specific state, then you're inviting me to be forced to do a calculation based on some sort of mitigation, right? That you freely move to California, you're mitigating against some of that discrimination. Do I need to net that out?
Briggs,
Black people in California have greater wealth than Black people in Mississippi. Do I need to net that out? Because if I'm, doing this broader calculation, do I need to net out that you weren't like growing up in Mississippi? These are the things that you invite when you dig into it and come up with what is it that someone from California would be owed if you're going to make that broader case.
Thank you for that. Okay, so we are into the lunch period time, and thank you for those comments. And I just wanted to make it clear that the experts as economic consultants are here to take direction from the task force. They're here to calculate the cost, and their ideologies per se aren't necessarily driving this effort. What's driving this effort is what the 9-member task force decides, right? So thank you for that. So now there is some things that are up in the air now because, as Casey Campbell and other folks said, the vote for who should be, eligible for reparations under the community of eligibility discussion would have been somewhat determinative in terms of guiding these expert economists on the work that they need to do. So And that would have also clarified any motion on the floor related to their work. But does any task force member want to make a motion on the floor related to the continued relationship or partnership with these task force, and not necessarily their scope of work, or mentioning some of the things that Member Grills or others talked about? So just opening the space for a motion on the floor related to the relationship between the task force and these experts that just introduced themselves.
Chair Moore, my understanding is that we are really voting on the members of the expert team, and that there was going to be a discussion about the issues that needed to be discussed, but that we definitely are not in a place to give them direction. But I think we are in a place to vote on the members of the expert team. And so if my understanding of things is correct, I would like to move that we vote to approve the expert assembled to the I don't know what to call it, the calculations associated with harms.
I would second that motion, because I believe Dr. Grills has clearly stated earlier. I think we just need a little bit more meat to direct them, as Dr. Spriggs has stated. I think also that needs a little bit more clarity. So I think I'm ready to approve the team, but we still have to do some work as a task force to further direct them. So I'll second that motion.
So the motion has been moved and seconded. Now we're in the discussion period. So my question is to Member Grills as to how your motion was formulated. It seemed like there was just harms focus, and so I wanted to ask you to clarify the motion that you're making. Are you saying, clarify the motion that you're making, and is lineage a part of your vote, is the motion as well?
No, I'm purely speaking about voting to approve the expert team. Can't hear you.
The motion on the floor is to approve the expert team. You said something afterwards. I wanted to clarify what the actual motion is.
It was really just additional verbiage. We're approving the economics team so that they can, do the work of calculating an amount or a redress associated with the harms. But that's the key point, is a vote to approve the expert team.
Okay, thank you. So it has been properly moved and seconded that the task force ratify the work and approve the expert team on the work that's been done thus far. Is there any discussion on the matter?
I have a quick question. Is there a time? Oops. Hello?
Go ahead, you're recognized.
Is there a timeline for when they need to complete their work? Or do we need to put time constraints, not constraints, but so that they get back to us in a timely manner so that we can use this information do they know what those timelines are?
The Darity or the Research Center, we discussed this.
So our impression was that our responsibility would be to prepare the second report for the task force, subject to the task force approval. And because I believe Chairman Moore and Member Lewis are going to be in continuous consultation with the team, in addition to, I guess, regular meetings with the task force, we would make sure that that report was fully consistent with the task force's expectations. So the timeline or the deadline for the measurement team's activities would be set by the deadline that exists in the law for the timing of the second report for the commission to be completed.
Okay. Thank you.
Chair Moore, if I may.
Yes, Mr. Newman. Attorney Newman.
Thank you very much. So we will, this was laid out, I think, a couple meetings ago, but just what you voted on and settled on is a plan moving forward. We need to work on the development of the scope of work with the experts, and Chair Moore and Member Lewis are working on an advisory committee to help develop that scope of work, although it's very clear from this conversation that that's going to require probably to come back to the task force again. So we'll need to square away time in a future meeting in order for that to come back and have a fulsome conversation on that. But the idea is that the process will mirror the process we've undertaken in Report 1, which is, again, Chair Moore and Scott Lewis on a different advisory committee are developing a schedule for future meetings, and there's going to be work, and this will be presented. We have a little bit of time before we have to do this, but there will be work to align the future meeting schedule along with the questions that the experts are going to be tasked with answering, so that the task force is taking testimony and ideally making decisions and giving direction to the experts as you move through those questions that are set for, and I believe subsection 3 of AB 3121. So this is going to be an ongoing back and forth. It's not necessarily going to be something where one decision needs to be taken by the task force and the experts will kind of go off and do it themselves. But the experts are going to be, from here on out, engaging in independent work, independent research, just like the DOJ attorneys did for Report 1, and having this engagement process back and forth with the task force. And part of that will be the direct involvement of the advisory committee, Chair Moore and Member Lewis.
Thank you for that, Attorney Newman. Is there any other discussion on the matter, comments, or questions related to the motion on the floor, which is just to approve the experts as consultants?
Madam Chair, do you want to state that the experts as presented today, so that it's clear on the record that, because I didn't hear anyone identify who the experts were, so it would be those individuals who were presented today. So
okay, great. Thank you. Mm-hmm. So I'll clarify the motion, which is on the floor, and it is to approve the experts as presented today as consultants, whereby the advisory board committee members, Jovan, Scott Lewis, and myself will continue to work with them and bring updates for the next meeting. Any other comments, questions? Hearing no further discussion, Parliamentarian Johnson, may you please do a roll call vote?
Thank you. Chair Moore?
Aye.
Chair Moore votes aye. Vice Chair Brown? Member Bradford?
Aye.
Member Bradford votes aye. Member Grills?
Aye.
Member Grills votes aye. Member Holder?
Aye.
Member Holder votes aye. Member Jones Sawyer?
Aye.
Member Jones Sawyer votes aye. Member Lewis?
Aye.
Member Lewis votes aye. Member Tamaki?
Aye.
Member Tamaki votes aye. Member Montgomery Steppe?
Aye.
Member Montgomery Steppe votes aye. Vice Chair Brown? Okay. Madam Chair, there were 8 members voting, 8 ayes and 0 nays, and 1 not voting.
Thank you. There are 8 ayes, 0 nays, and 1 not voting, so the motion carries, and the economic consultants as presented are approved, and the advisory board committee that consists of myself and Jovan Scott Lewis will continue our working relationship with them and to provide a substantive update at our next hearing. Thank you very much to the California DOJ Research Center, to Attorney Newman, and all of the experts that came to present and introduce themselves. We're looking forward to working with you all. So it's now 12:33 and we're into our lunch hour. So we will return promptly at 1 o'clock. Thank you very much and see you all at 1. It is now 1 p.m. And before I call the meeting back into order, I'll call on Parliamentarian Johnson so that a quorum may be reestablished. Parliamentarian Johnson?
Yes, thank you, Madam Chair. Chair Moore? Vice Chair Brown? Member Bradford? Member Grills? Member Holder? Member John Sawyer? Member Lewis?
Present.
Member Tamaki?
Present.
Member Montgomery Stepp?
Here.
Member Grills?
Present.
Madam Chair, there are 9 members on the task force. 5 members are needed for quorum. We have 5 members, and a quorum has been established.
Thank you. Thank you, Parliamentarian Johnson. Now that a quorum has been reestablished, I'll officially call the reparations hearing back into order. So the next item on the agenda is agenda item number 17, discussion item, review and discussion regarding draft of report 1. And we have up until 2:45 p.m. for this item on the agenda, which will be led by DOJ staff Attorney Newman and Attorney Yang.
Thank you, Chair Moore. Thank you very much. Once again, so members of the task force, I am Michael Newman. I'm the Senior Assistant Attorney General of the Civil Rights Enforcement Section. You all have been provided drafts of the hundreds of pages of report that have been compiled by my count, more than 20 people working on our staff here in the Civil Rights Enforcement Section in some capacity to conduct research, analysis, drafting, working with you all through the outlines, and providing this draft report. The draft report reflects the feedback and suggestions we've gotten from members of the task force, our experts that you heard from several of them earlier this morning, and also relies on empirical evidence, studies, published materials, peer-reviewed materials, and is extensively footnoted. I reiterate, though, that it's a draft, and we provide the draft for the consideration of the task force. And we will, as I mentioned in my DOJ update in the last meeting, we will be looking for members of the task force to directly and actively engage with our staff in order to make sure that the final report, which this is